All right, and the court will call the matter on the calendar, State v. Laura Owens, case number 2025-007905. Can I have appearances, please, starting with the state?
Good afternoon, Your Honor. Ed Lyron, Best State.
Afternoon, Your Honor. Christian Lueders on behalf of Laura Owens, who's present with me at the defense table.
And good afternoon, Ms. Owens. Can I have you state your name and date of birth?
Laura Owens, 5/14/1990.
Thank you. And you can be seated, Ms. Owens, if you like, if that's more comfortable for you. Okay, and so, Ms. Owens, my name is Commissioner Simon, and I've been asked to do the settlement conference in your case today. And this is an informal setting where you'll have the opportunity to talk about your case if you want to and to see if we can get it resolved. And we're going to discuss, and you can ask questions about the plea agreement that you've been offered in this case, and the options that you have in this case and the potential range of penalties. So I'm going to try to just go over all of that with you. Do you have any questions for me before we start?
Not right now, thank you.
Okay. And so even though we are on the record today, so nothing here can be later used in your trial. My role is just to help facilitate a possible settlement. And I won't have any other role in your case. So if your case goes to trial, I'm not going to be presiding over that trial. I won't be ruling on any legal issues in your case, and I wouldn't be the judge that ultimately sentences you unless you take a change of plea in my court, and then you want me to do the sentencing. Other than that, I won't have any other role in your case besides today and just going through this settlement conference and again seeing if there's any issues that we can resolve today. Do you understand all of that?
Yes, thank you, Your Honor.
Okay, and so my role isn't to force you into taking the plea or going to trial. That's only your decision. I'm just going to, again, help you get as much information as you can about your case while you still have some options. And I know that there is a current plea offer on the table. And so I guess we can kind of go over those options. So between now and whenever that plea agreement expires, I don't think that there's an expiration date on the plea agreement currently. You have the option to take the plea, or you can reject that plea and you can choose to go to trial. Or if there is an expiration date on that plea, or when there becomes an expiration date on the plea agreement, and you don't accept the plea agreement by that date, then the plea may expire, and then the only option you'd have at that time would be going to trial on this. You understand that?
Yes, thank you.
Okay. And so I did spend a few minutes in my chambers with the attorneys in this case to learn a little bit more about you and the charges and the plea offer. And I just want to go over with you the, I guess, best and worst case scenarios in your case if you decide to take this to trial. Okay. And so if you do decide to go to the trial and you don't want the plea agreement in this case, there is a possibility, obviously, that the jury finds you not guilty on these charges, which would be, I think, your best case scenario, right? So if you get the not guilty charges, but if the jury finds you guilty on any of the charges, then the judge would have to impose the sentence. And you are probation eligible, so the judge could, if the jury finds you guilty on any of these charges, I think there are 12 counts. On any of those 12 counts, the judge at sentencing could place you on probation for each of those counts. With any probation term, a judge can impose up to 12 months of jail as a term of probation. Do you understand that?
Yes, thank you.
Okay, and if you don't get probation, the judge may sentence you to prison. And so I think there is so Arizona has a statutory scheme for prison terms for each kind of offense. And so if you look at that sheet right there, that'll give you a kind of rough outline of the ranges of penalties for each type of offense here. So you're being charged with 11 Class 4 felonies, 2 Class 2 felonies, and 1 Class 6 felony. So if you look at that, I think it's in an orange box towards the top of the page, you'll see for the Class 2 felony that the lowest sentence is 3 years, and the aggravated sentence is 12.5 years. For the Class 4 felonies, that would be a mitigated sentence of 1 year, and the maximum would be 3 years on those. And for that Class 6 felony, the lowest would be 4 months, and the aggravated, which would be the highest, would be 2 years. And so with all of those ranges, the P right there, that column that has the P, that's a presumptive term for each of those classes. So the presumptive term would be 5 years for the Class 2 felonies, 2.5 years for the Class 4 felonies, and 1 year for the Class 6 felonies. And generally what judges do is start at the presumptive term and then would, if they think prison is appropriate, and would either go up to an aggravated sentence, anywhere between the presumptive and the completely aggravated sentence for each count, or if they think there's mitigating factors, would lower that presumptive term to anywhere between the mitigated. But the mitigated sentence for each of those classes is the absolute lowest that any judge can go when sentencing on those prison terms. And again, you may know all of this information, but I just wanted to go over this with you to make sure that you understand all of that. Do you have any questions about that?
No, not so far. Thank you.
Okay, and I think that since there are multiple dates of offense on these, that they can run consecutively, which means that those terms would run one after the other, or the judge could also find that they're going to run concurrently. So if you're sentenced on multiple counts, if you're found guilty on multiple counts and you're sentenced, the judge can have those run concurrently, so those prison sentences at the same time, or consecutively, which means they'd run one after the other. Do you understand that as well?
Yes, thank you.
Okay, thank you. And so if you go over the maximum, the term that I guess if you took this to trial and it was the absolute worst day that you could have at trial, so for the Class 4 felonies, again, this is all, some of them may have to run concurrently, but just assuming for today's hearing that they'd all have to run consecutively, one after the other. For the Class 4 felonies, with the 11 of those, that would be over 37 years for those. And for the Class 2s, it would be over 25 years for those. And for that Class 6, it would be 2 years on that one. So if you add those up, it would be a significant amount of time. And I'm just trying to tell you this just so you have the information. I don't think that's likely to happen if a judge would sentence you to prison on those counts. But I just want to give you all of the information as to the possibilities, the worst case scenario on all of those. And do you understand that?
Yes.
Okay.
You.
And so if you do go to trial, you are leaving the sentencing up to the judge's discretion. You wouldn't have any control over that decision, and the state would make arguments as what they thought the proper sentence would be. Your attorney would make arguments as what he thought the proper sentence should be in this case, which would likely be the lowest possible sentence. But it's ultimately up to the judge to decide what the proper sentence would be. And again, the judge would likely, if they thought prison was appropriate, start at that presumptive and then go either up or down from there, depending on the aggravating and the mitigating factors that they have found. And so I do want to just kind of go over briefly with you the current version of the plea agreement. Just give me one moment. I'll pull that up. Okay, and so it does have, as to count number 1 on here, there's no agreements as to that count. So it's kind of, self-explanatory in there. The judge can sentence you to prison or give you probation on that. And again, with the probation, the judge can sentence you up to 12 months in jail as a term of probation in that. Anywhere between 1 day and 12 months if they wanted to do a little bit of jail or no jail attached to that probation. And with that Class 2 felony, again, with the higher level of felony offense, if they thought prison was more appropriate for that count, and this is if you entered into the plea agreement, it would be between 3 and 12 and a half years, and the presumptive term on there would be 12 and a half years. And for the other counts, the other 3 counts, those would be for probation. And again, you can get up to 12 months on any of those counts as probation if the judge deems that appropriate. And do you have any questions about the plea agreement?
No, thank you.
Okay, thank you. Mr. Leiter, I don't know if you wanted to go over the plea agreement, maybe how the state arrived at that plea agreement, and if it can get any better, and if not, I guess, what's your position on that?
Well, and to clarify one item, Your Honor, the plea agreement, which was sent to defense counsel over a month ago, it does expire today.
Okay.
And one of the issues, and I do want to express, and I think one of the victims wants to address the court, the frustration, and this is often a frustration that all parties, but often victims specifically, feel in terms of how long the justice system often takes. In this particular case, it's relevant to know that there was an original indictment. There was a subsequent indictment in which a second victim was added, and then Ms. Owens, Mr. Luters is now her third attorney. So that whenever additional attorneys come onto a case, or a new attorney, that tends to drag the case on further. And certainly I understand, and the victims, rightfully so, are deeply frustrated about how long this is taking. One of the issues, and it provides the crux of the state's case against Ms. Owens, is that the vast majority of our evidence against her is digital forensic evidence derived largely from her cloud account, cell phone extractions, among others. As a result, that evidence is voluminous. I think we're multiple terabytes of data. And the state has moved as quickly as we can to get that information in front of Mr. Luters. But as I understand it, he can explain this a little in more detail. But there has been some issues in terms of his ability to review some of that evidence. We made a large hard drive available. I moved as quickly as I could to get information because he was not able to review it. But it is unfortunately a function sometimes of digital evidence, particularly when it's this much, that we run into technical snafus, and that appears to be present in this case. I am cognizant of the victim's desire to resolve this and belief that this plea should be entered in today, or we should go to trial. I know that that's what they want. But I also am aware, and the court, if Your Honor could weigh in on this, in situations where a defense counsel has indicated that they have not had an opportunity to review all of the evidence, at least in a timely way, and importantly, communicate that and have the conversation with their client. What is the state obligated to re-extend offers, or what could be the possible consequence if we refuse to re-extend an offer, Your Honor?
Well, yeah, it's the victims, Mr. Luters, and I do understand the frustration that this case is taking longer than you'd like, but Mr. Luters does have an obligation to properly advise his client on how to proceed, and in order to do that, I think he has to review all of the evidence. So, if he were to go to trial without having to review all of the evidence, or the court didn't give him that proper time to do that, I think there would be the case wouldn't be as closed as quickly as maybe you would like, because I think it would open the case up for potentially an appeal and possibly going back to trial on that. So I think the idea is that if we can give Mr. Luters the opportunity to review all of the evidence here, he can properly advise his Ms. Owens and prepare for trial. Then all the parties can, and if the trial is what happens here, then the parties can hopefully have an opportunity to litigate that based on all of the facts that were presented, and again, allowing Mr. Luters to know all of those facts and all of the evidence that's out there. And so that would be my position on that, is that the court would give Mr. Luters the opportunity to review all of that evidence, given the terabytes of evidence in this case. And I don't know any of the specific evidence, but given the terabytes, I would think that would take some time to go through. So I'd be inclined to give, and it wouldn't be, again, me ruling on this, but any judge would be inclined to give Mr. Luters time to review that.
And Judge, it's recognizing that courts are amenable to giving counsel opportunity to review the evidence. Is that, 6 months, years?
I think it's just a reasonable time, depending on the amount of evidence. Okay. I don't know if you can put a time frame on again what's reasonable and how long it would take to go through the evidence in this case.
And I think getting back to the court's initial question, and as I said, the crux of the state's evidence comes from the cloud information that was obtained by detectives and investigators with the county attorney's office, which the state believes will show that Ms. Owens engaged in multiple schemes with both Greg Gillespie and Clayton Eckhart as victims, purporting to be pregnant, and the evidence, again, derived from the cloud information, is going to show that she was not. This case originally came into the county attorney's orbit, Your Honor, from another Superior Court judge, Judge Mata, who, during a civil case involving the victim, Clayton Eckhart, came to the belief that Ms. Owens was lying on the stand. So there was a referral to the county attorney's office for perjury, so at least one or potentially multiple perjury charges. From that information, detectives with the county attorney's office then proceeded with a more robust investigation that included examination of depositions made in the civil case, which included a great deal of text message information which supports the now 14 charges that we have made, including the underlying and overarching fraud schemes as to both, which are the class 2 offenses, which carry with them the 3 to 12 and a half years, at least potentially, of prison time. And the state will be able to show through that data that Ms. Owens sent videos, doctored various medical documentation, all purposed for convincing Clayton Eckhart and Mr. Gillespie of her pregnancy in order for them to comply with her requests, some of them being to continue to date her, to be seen with her, and so those are good. That's really going to be the focus of the state's ultimate prosecution, including lots of transcripts from depositions and the trial itself to demonstrate that the statements that Ms. Owens made on the stand and in deposition and sworn deposition were in fact false. And I'm happy to answer any other questions that you may have.
Do you have any questions about that, Ms. Owens?
I think from our perspective, one of the toughest things to understand, and I've spoken about this with Laura, but one of the toughest things to understand is the obtain a benefit portion of the fraud schemes counts. I think, listen, the evidence of perjury is strong. You and I have talked about that. When it comes to the obtain a benefit portion, what is the state's, if you can talk about that, what's the state's theory on that?
Sure. You're right insofar as it's not. I'm going to say, give me X number of dollars, or oftentimes in these fraud schemes, it's more clear cut. I think this is it's not as explicit. It is the benefit is the desired benefit that is in part driven by Ms. Owens's desire to be seen with, to be part of Mr. Eckhart's world. The text messages and the other evidence is going to support her desire to, I think, grow her own brand to some extent. And those are going to be sort of the driving forces, along with being seen with him. It's like I said, it's not, hey, do this and I'm going to get $100,000. It's a little more nebulous, but I feel confident that the state will be able to demonstrate through largely her own words in text message and emails what her desired outcome was going to be.
The other question we've kind of touched on this in conversations and throughout the case. There obviously is a lot of outside factor in this case. When it comes to the plea and how it was made, can you talk about how you guys came up with this? I know it was a group effort. I know it's not just one person over there, and I know it's not the county attorney over there. I know it's not just you, or maybe it is. How did you guys come up with the plea? Where did you?
Sure.
Because this is an unusual case.
Yeah, no, I can definitively say there's no outside influence or pressure. This plea does give Ms. Owens the opportunity to have straight probation, ultimately, recognizing that there is prison exposure in a no agreements plea. This plea was contemplated with the county attorney. Her and I discussed it. We thought this captured not a one-off, a person who, at least the evidence is going to support, that she engaged in fraud with these two gentlemen right here, but moreover and importantly, tried to perpetuate that fraud in the Superior Court. And our position is that needs to be held to account, and we believe that Ms. Owens is maybe differently situated than, and there are other examples of individuals who have purported to be pregnant to get a benefit from an individual. Ms. Owens has two different and unique situations. There's also, and I haven't spoken about this, but there's also the Stormy Mitchell, who is the woman whose ultrasound was used by Ms. Owens. That is actually a third a victim, and she feels very strongly about being exploited by Ms. Owens using her information and her the ultrasound that was hers. So it's our position that the no agreements and the multiple counts capture both the fraud perpetuated on these gentlemen, Ms. Mitchell, and importantly, the court and the system of justice that we have in Maricopa County. That being said, we are also cognizant of there's no direct violence. I mean, certainly these gentlemen feel violated, but that's why I think she is given at least the theoretical opportunity for probation ultimately.
Thank you.
Yeah.
Appreciate that. Is there anything else I think that's the only questions we have for now.
Okay.
Okay, thank you. And did any of the victims want to address the court today?
I think so, Judge. And then would you like them to come up to the podium, or what would?
Whatever they feel comfortable with.
Okay.
And I can just stand here. I don't know what all so much I can say. The big thing I want to focus on is not allowing an extension of the plea deal simply because she has a history of delaying. She's done it. She's on her, I think, 6th or 7th lawyer at this point. And it's just going to continue. My understanding is he's come into the case a few months ago. And this feels like an 11th hour push to say, I can't access the material. You know, to me, if you couldn't access the material, you should have accessed it day one. And every single day you should have been following up to get that evidence. I'm all for due process, but to me, this just feels like an extension of her tactic carried out by him to extend it. And it's been 3 years. I'm tired. I know we're all tired. And a ton of evidence, blatantly obvious. She's admitted on the stand to medical fraud. She's admitted to certain lies. It's a clear-cut case. She's guilty. There's no reason to drag it out and say the terabytes of information are going to somehow change something. But my biggest focus is just, and I don't know the answer to this, but to me, a little bit of common sense. When did you come in? When did you get the material first sent to you? And then how hard did you really try to access this material? To me, lawyer should be trying to access it every single day, not waiting in the 11th hour and saying he hasn't had enough time to review it. That just feels like a delay. So that's just the thing I want to highlight. What's enough time? You know, give him another month, another 6 months. I mean, there's nothing in that terabyte of information that's going to all of a sudden open her up to innocence. It's just, it's in my opinion. I'm just giving my opinion, but
No, I appreciate that.
I just, another month, 2 months, 6 months, it doesn't make a difference. The outcome's going to all be the same. So I would just like to, me personally, not extend this. She either chooses to take it or not. It's been laid out. she understands, she knows she's guilty, so she just needs to either take it or go to trial. To me, it's just a straightforward thing. But I just would like to know how much effort he's put into actually accessing the documents. I think that's important to take into consideration.
Yeah, Mr. Litters, I mean, do you have any ideas how long it will take you to get to that information or
What's
review
the
that
specific
information?
question? The specific question is how hard I've tried.
No, I don't think, I guess this is it would be more of a question for the case management judge. So I guess I don't really need to talk about that today, because I think if you did have that is really more for the case management judge.
What I'd like to add, Judge, is I certainly understand Mr. Eckert's frustration. What my intention to do starting this weekend is to identify the specific exhibits that's within this voluminous discovery and identify those and try to get those to Mr. Luter's early or by midweek. Here are, basically I'm going to do a show up. Here are what I expect to be the exhibits at court. I think maybe that would help him really be able to wrap his head around what the state's evidence looks like and then communicate with his, and I hopefully that can expedite this process.
Yeah, we talked about that. That's a really good offer. It's thoughtful, and I think it will help. But yeah, I mean, I can safely say, and I've made this clear to the prosecutor's office for the past month and a half or so since this was officially disclosed. It actually was disclosed to her previous attorney. That's not incorrect, but there was nothing done about that information with any of the previous attorneys. I can safely say that we're the first ones who have actually started to look at it, and we have done everything we can up to this point to do that. That's what I'll say.
Thank you, and I appreciate that. And sir, I do appreciate your perspective on that and wanting to move this case forward. And again, I think if there's that is a determination for the case management judge. He or she would have more information on the case and what's appropriate. So, but I can't say Mr. Luter's has appeared in front of me numerous times, and I don't see him as the type of attorney to try to unreasonably delay things. It sounds like he's trying to do his best to review the information best he can and move things along the best he can. Does anybody else have any questions? I want to put anything else on the record. Yeah. I got you.
If this attorney does not stick around, what kind of, in my profession, we have to put, it's just lights, but there's a strict guideline to follow, a protocol and a time frame. If Laura attains new representation, are we going to put any time frames around that so we're not doing this over and over and over again?
Again, I think that would be an issue for the case management judge, but given the circumstances and the length of time this case has been going on, let me just look at the docket really quick in this case.
For me,
but if there was a new attorney, yeah, sorry, go ahead.
It's 2021 when I've been dealing with this.
Okay. Given the circumstances, I would think that if there was a new attorney on the case, the judge would try to put some parameters in place. But again, it's really difficult for me to say what those parameters would be. The case management judge would be in a much better position to determine that and talk to you about what they thought was appropriate if there was a new attorney coming on. But I do understand your concerns and your frustrations in that regard and wanting to get this case moving and see that justice is done. And I think that the judges also have a packed calendar too, and they also want to see resolution of these cases. They don't want to see these cases unreasonably extended. So they also want to make sure that these cases are moving along as quickly as possible. Again, with also balancing that with complying with any due process rights and just making sure that that Mr. Luter's or any other attorney can properly advise their clients on how to proceed. So I know that's not the answer necessarily that you're looking for your question, but unfortunately that is like the best I can do, and that's where I'm at in the circumstances where I'm at.
Thank you, Your Honor.
Yep.
Your Honor, if I may.
Yeah.
Certainly in my experience, and I think Mr. Luter's experience, in a situation like this, if Ms. Owens were to get another lawyer, many judges, given particularly the victim's input, would require that counsel avow to readiness within a short period of time. You know, if we're a month from trial, generally speaking, courts are going to say, well, can you be ready for trial? If the answer is no, then they're not going to allow new counsel to come on board. Is that fair?
Good point. Yeah.
I mean, it's actually, it's by rule.
Yeah.
Yeah, if there's a set trial date, that new attorney has to avow that they're gonna be ready. That still doesn't mean that there's not gonna be an extension, as Your Honor knows. Things happen, exigent circumstances, whatever it is. So, you know, I can safely say that we are working with due diligence on this case.
Okay. Does anybody else want to be heard? Okay. So it sounds like we're not going to be able to get the case resolved today, at least this current version of the plea agreement. Would that be fair?
That's fair, Your Honor.
Okay. Is there anything else that we need to address today? I know we do have, there is a case management conference, looks like tomorrow on Monday in front of Judge Reuter. But was there anything else that we needed to talk about today?
I don't think so, not from the defense's perspective.
Ms. Owens, did you have any questions for me?
No, thank you, Your Honor.
Okay, thank you. Mr. Leiter, do you have anything else that you wanted to
Nothing from the state judge.
Okay. Well, I appreciate you all being here this afternoon and discussing and sharing your concerns as well.
Thanks, Judge.
All right. Thank you.
The settlement conference became a clash between the prosecution's push for resolution and the defense's need for more time. Prosecutors pointed to massive digital evidence and serious felony allegations, while the defense argued it needed time to review the evidence before advising Laura Owens. A victim strongly opposed any further delay, calling it a tactic to prolong the case. But the judge emphasized due process and the defense's right to prepare. In the end, no agreement was reached, and the case moved forward toward the next stage. Thanks.